Hi, I'm Ravichandran Kirtivasan, founder of Pisence Technologies. If you run a business in India, any business of any size, there is a date you need to have in your calendar, 14th of May 2027. That's the day India's Digital Personal Data Protection Act, DPDP, stops being a piece of paper and starts being something a regulatory can fine you over. Now, lots of people heard about the DPDP Act mostly in the 2023. Decided it didn't apply to them, and most of them moved on, and some were right and most of them were wrong. So over the next couple of minutes, I'm going to answer three key questions in a layman language. Does this law apply to me? What exactly do I have to do? And what happens if I don't? Okay. Let me start with the number because it's a thing that gets attention. 250 crores 250 crores INR. This is a maximum penalty for a single failure, failing to put reasonable security safeguard in place. Three things about the number that people miss. First, it's per violation, not per year. It's not an annual cap, multiple failure stack. Second, there is no size discount. This law doesn't say 250 crore for bank and 5 lakhs for startups, and it doesn't say anything like that. A 12% company can be doing the same, and even the multi-billion-dollar company could get the same. So third, the clock is already running, not from 2027, from today. So I will come back to why that this is in the next 3 minutes. So this is what we are going to cover in the session. So we'll start with the law and the clock, what's actually enforced right now, and what isn't. Then the big one, who this applies to. If you take nothing else from the session, take section 2. Okay. Then the rules, the data principles, data processors, concern managers, and the 8 obligations that land on every single business. Then we go to rights. Then breach of reporting, security penalties, and this is where the most companies are quietly non-compliant today, and they don't know it. Then some special cases, children data, cross-border transfers, and what happens to the customer data you already collected. And we finish with the practical, some like a roadmap, 18-month roadmap. What to do in the month 1 and the 6th and then 12th. So we'll go into the law 1. So from the act to enforcement law. So quick history, because this explains a lot about a lot of the confusion out here. The DPDP Act got presidential assent of 11th of August 2023. Big headlines, India finally has a privacy law. Then nothing happened for more than 2 years. It's 2026, so it's almost 3 years. Why? Because the act was a skeleton. It said you must obtain a valid consent, but it didn't say what consent, what notice must it contain. It said the reasonable security safeguards without saying what reasonable means. All of the detail was left to the rules, and the rules didn't exist. That changed the 13th of November 2025 when Medway notified the final DPDP rules. They were published in the central. They published officially next day of 14th of November. Small note: you'll see both dates quoted in the article. The notification is dated on 13th, published on 14th. Rule 1 ties to the compliance milestones to the date of publication. So throughout the session, we'll use the 14th. Okay. And here's the part most business have missed. Data Protection Board of India is already constituted. The definition in the Act are already legal and operative. Complaints can be filed against you. It can be What hasn't switched on yet is the penalty machinery. So that's coming. Okay, this is the three phases. 14th of November 2025, phase 1. Already behind us, the data production board goes live. All the definitions became operative. The complaint mechanism open. So 14th of November 2026, phase 2. Consent manager registration opens. It will explain a consent manager shortly, and the penalty provisions come into the picture. And 14th of May 2027, phase 3. Everything notices, consent, security safeguard, breach reporting, data principal rights, significant data fiduciary, cross-border rules, all enforcements with penalties attached. So we can expect it on May 2027, 14th. So almost 18 months from the notification to the full compliance. So now a lot of board heard 18 months. So under it, so let's start in Jan 2027, and I will be rebuilding the systems under live enforcement with the regulatories are already taking the complaints. Okay. So what's live now versus 14 May 2027? Let me make that clear, okay? Because the gap matters. Live today on the left, the board exists, definitions are in force. A customer can walk up and file a complaint about how you handle their data, and no penalties are being enforced right now. I'm in the live today. And from 14th of May 2027, on the right, notices and valid consent, reasonable security safeguards, breach reporting, data principal rights, significant data duties, cross-border rules, all of it, all of the enforceable with the penalties we looked at. So what is this window really? It's build time. It's not anything like, and also it's certainly not permission to ignore this until 2027. Think of the way you think of like a factory inspection that's been announced 18 months in advance. The inspector isn't arrived yet, so like that you just have assumption. But the date is fixed, everybody knows it, and we ran out of time. It's not going to be the interesting difference. Okay. So who it applies to? Let's be precise about the scope because this is where most of the myths lie. Okay. Any entity processing digital personal data of people in India, that's the core test. Not your size, not your sector, not your revenue. Do you process digital personal data of people in India? That's a key. Second, the law reaches across borders. A SaaS company in Austin, Texas, with Indian customers is covered, or a European manufacturer selling into India is covered. If you are offering goods or services to people in India, the DPDP Act follows your home. It covers, yes. Third, and I want to slow down here, there is no turnover or headcount exception, known like unlike some other justifications in India did not crave the small business like 12 people or 13 people companies. So and fourth, and this is one that catches people. It's not just customer data. Employee data is personal data. Vendor contact data is personal data. IP address and cookies are personal data. Your HR file and the junior developer suits everything the same law as customer database. So everything is covered. So out of scope, purely offline, non-digital records, if it's in the physical register and never gets typed into anything, it's outside the act. Personal or domestic use, your own contact list on your mobile phones and data that an individual has voluntarily made public themselves. Someone who publishes their own phone number on public profile So notice how these narrow exclusions are. For the functioning modern business, essential, nothing you do not fall outside this law. 3% startup with a website, contact form is, yes, it's included. The same status as bank. So it doesn't matter if you are a small or big. People always ask, is my industry affected? They can be in the fintech, they can be in technology, in SaaS, anything. People always ask, is my industry affected? So let me run through the obvious ones and then give you the actual test. Regulated and financials, banks, NBFCs, insurance, they're already in the regulated. So they are the furthest right. Real estate, which collects enormous amount of KYCs and financial data and is typically least prepared. Staffing and HR firms and those entity product is personal data. And health and education, health tech and clients, edutech and coaching centers. And know that last one, because coaching centers process children data at scale. So enormous number of data. And children data has its own set of rules and 200 crore, 250 crore penalty ceiling. Yes. Digital and consumer, e-commerce, D2C brands, SaaS, IT services, including service companies who think they are safe because they only processor, and will come back to that hospitality. But here's the honest answer to, is my sector affected? If you collect a name, a phone number, or email address, you are in scope. That's a whole test. It doesn't matter what you sell. Okay. Now some good news, because it isn't all burden. Consent is the default. Most processing needs individual free informed consent, collected upfront, and withdrawable at any time. But the Act recognizes a set of certain legitimate uses where you don't need a separate consent form. Data a person voluntarily gave or for a specific purpose, employment related processing, government benefits and services, medical emergencies and disaster response. These things can be. Let me make employment contract because it's one that affects every single business in this room. So your HR team process an employee bank account details to run payroll. That's employment. It's a legitimate use. You do not need to make her sign a separate data consent form to use her to pay her salary. Now take those same bank details, hand them to your insurance partner, and pitch her a personal loan. So it's a different purpose. That's not employment anymore. So you need consent. So and that's a mental key model I would like to carry for the rest of the session. Under DPDP, the question is never, do I have this data? The question is always, for what purpose do I have this data? And am I still using it for this purpose? So this is things you have to ask yourself. Section 3, the 4 roles and the 8 things every business has to do. 4 terms. Okay, 4 terms. Learn this 4 and 90% of law becomes readable. Data principle. The individual data is about your customer, your employer, your employee, your user. In most other laws, this person is called data subject. India choose principle, but and the word is it's complicated. So principal is someone you act on behalf of. Okay. Then whoever decides why and how data is processed, this is you for your own business. And then note the word again. So that's a word borrowed from trust of law. It implies a duty of care that runs beyond the following rules. And now we go into data processor. Anyone who processes data on Data Fiduciary, we have under contract your cloud provider, your payroll vendor, your email marketing tool. So data processor. Consent manager, a registered platform where individuals give, manage, and withdraw their consent. This one is genuinely new. That there is no clean evaluate in GDPR. So I will give it on its own slide. The critical thing here, the obligations sit on the fiduciary. You can outsource the processing. You cannot outsource the accountability. So one order, four rules. Four rules. Let's put all four into one 30-second story. Okay. Shalini buys a face serum from ABC, a D2C brand, on their Shopify store. So the ABC also runs WhatsApp offers through marketing agency. One transaction, four rules. Shalini is the data principal. It's her data. So ABC is the data fiduciary. They decided to collect her number and they decided to use it for marketing. They set the purpose, so they carry the duty. Shopify and WhatsApp agency are data processor. They handle her data, but on ABC institution under contract. Okay, and the consent manager is the platform where Shadi can go and review and withdraw what she agreed to. So now here's the sentence that matters. If that marketing agency scrapes Shalini number into a separate campaign for different client, ABC is answerable, not the agency. ABC is answerable. So you are accountable for what you process in a chain, does with your data handling them, which means your vendor contracts just became a compliance control, not a procurement formality, right? So next, concern managers with plain terms for the layman language. So the concern managers, this is the most India specific piece of whole framework and honestly one of the more interesting ideas in global privacy law. What they are, a registered interoperable platform where a person can give, review and withdraw consent across many different businesses from one place. Registration opens for 14th of November 2026 and there is a minimum net worth required of 2 crore rupees. So these will be serious regulatory entities. Why that matters? It creates a neutral record of consent sitting between the individual and every business that holds their data. And critically, the concern manager is accountable not to the board, not you, not to the vendor, not your vendor. Okay. So it's think of it like DigiLocker for but for permissions. Right now, if someone wants to stop marketing message from 10 different companies, they have to hunt through 10 different apps, find 10 different unsubscribed flows, three of which is deliberately buried. Under this model, they open a dashboard and switch you off. That's it. And you have to act on that. So here's the engineering consequences, and I will flag this to your CTO today. Your system needs to be able to receive and withdraw signals from outside your own product and act on it. If your consent state also only lives inside your app, you have architecture work ahead of you. Okay, so you have to mention that to your CTO. So 8 obligations for every business. This is a core checklist. 8 obligations and these apply to every data fiduciary, the 3% startup on the bank alike. One notice it missed and in plain language. not a 12-page term document, and it has to be available in English or in any scheduled Indian language at the individual's choice. Okay. So two valid consent, free, specific, informed, unambiguous, and this line is one of the one that will break most existing implementations. It must be as easy to withdraw as it was to give. But if signing up takes one click and opting out takes an email to support, and 3 days you are not a complaint. Okay. Three, the purpose limitation. Use the data only for the purpose you started. The payroll to person or person to loan example from earlier. Okay. Four, the retention limits. Erase once a purpose is served or once consent is withdrawn. Most Indian companies today have exactly one retention policy. Keep everything forever. That is now a liability, not an asset. Five, security safeguards. Reasonable technical and organization measures, and will define reasonable precisely in few minutes because the rules actually name them. Six, eight, fulfillment, rights fulfillment. Access, correction, ensure and nomination request. You need a process and not a goodwill. 8, grievance and resol, a reachable officer and resolution within 90 minutes max. 8, the processor contracts. Engage processor only under a valid contract. Every vendor touching a personal data needs a data processing agreement. If you are onboarding a tool by clicking I agree on a sign up page, that needs revisiting. Okay. 8 items, screenshot the slide. This is your gap assessment. Section 4, what individuals can ask of you, what they owe you. Okay. Access a person can ask a summary of what personal data you hold about them and importantly whom you shared it with. The second part is that is the hard one. Most companies can tell you what's in the database. Very few can tell you the downstream vendor that data went to. Correction and competition. So, this correction and completion, fix what's wrong, complete what's incomplete. Then ensure, delete when the data has no longer needed, then the grievances and result answered within 90 minutes. And then the one that's unique to India, the nomination, an individual can name someone to exercise their rights on their behalf of if they die or become incapable. That's a real equivalent to in the GDPR. It's a thoughtful provision and practically it means the right management system needs to handle request from someone who isn't in your account holder. A customer email, let's say in practical, a customer emails you, take my account and everything you have on me. The clock starts, you must erase the data and must tell the processor as erase it in the next few minutes unless the drawer requires you to read it. Okay. Ignore that email if doesn't just go away, it becomes a grievance and that grievance escalates to board that is already sitting and already accepting complaints. Okay. It cuts both ways. Now a slide I enjoy because it's a part nobody expects. The DPDP Act places duties on individuals to don't file false or if you raise complaints. Don't impersonate someone else when providing data. Don't suppress material information in official documents. And that's a penalty attached. There's definitely a penalty. A data principal who breaches the duties can be fined up to 10,000 rupees for the individuals. In practical, let's take like this. Imagine ex-customer decides to flood your grievance channel with the fabricated breach complaints purely to harass you. Under this act, the board can penalize the complainant. So I don't want to oversell it. 10,000 rupees against 250 crore is not a balanced scorecard, and this is still very much law designed to protect individuals, but it doesn't mean the framework isn't purely one directional. There is a check and bad faith complaints. Okay. So section 5, breach security and penalties. If you stay awake for one session, make it this one. Okay. This is, in my experience, the single most commonly misunderstood thing in India's data complaints. So let's be very clear. When you have a breach, two clocks start at the same time, 6 hours. Okay. CERT-In. You report a cyber incident in a CERT-In within 6 hours of detection, and I want to stress this is not new, and it's not coming in 2027. This is mandatory today under the Act 2000 by the 2022 CERT-In directions. Okay, if you are not doing this already, you are currently non-compliant. Right now, this morning, independent of DPDP. Okay, 7 hours, 72 hours. The Data Protection Board notifies the board without any delay. Notify the board without any delay. File a detailed report within the 72 hours and inform every affected individual. There are parallel obligations, not alternatives. Most breaches trigger both. Reporting to CERT-In does not discharge your duty to the board, and reporting to the board does not discharge CERT-In. And there is a no materiality threshold. One affected person carries the same duty as million. So the practical takeaway where incident response run book or rule book needs a 6-hour lane and a 72-hour lane with the named owners for each dedicated people. 6 hours is not enough time to hold a meeting about whether to report. That decision has to be pre-made and documented. Okay, so what reasonable security actually means. Everyone's first reaction to reasonable security safeguard is reasonable according to whom. It sounds like a kind of org standard that gets argued about after the fact. Okay, right? Except the rules actually name the measures. Okay, encryption, obfuscation or masking, access control, lodging and monitoring capable of detecting a breach, backup for continuity, and the security terms written in your processor contract. So reasonable isn't a philosophical question. It's closer to the checklist, which is good news and bad news. Good news, you can tell whether you have done it. Bad news, so can the board. So in practically, if I have to tell you, take a misconfigured database, no encryption, no access log, that leaks 40,000 customer records, something we see regularly. That isn't just a breach because none of the named safeguards were in place. It is a security safeguard failure, and most of the expensive categories, the Entity Act, okay, the 250 crore ceiling. The distinction isn't worth internalizing. A company that has encryption, access control, and lodging, and still got breached by a sophisticated hacker is in a very different position from the company that has none of them. The first is unlucky, the second is negligent, and the rules now define exactly what the negligence look like. Significant data fiduciary. Some organizations get an extra layer of obligations. There are significant data fiduciaries, SDFs. How you are designed, okay, by government notification based on a volume and sensitivity of your data you handle. the risk of individual rights, and consideration of national interest. Okay, and I want to correct a widespread misconception here. There is no published numeric threshold. They do not become an SDF automatically by causing some user count. It's a designation by notification, not by a head count. What it adds: a annual data production impact assessment and independent audit, and algorithmic fairness review, which matters enormously if you are using ML for lending and decision hiring, pricing, or content ranking. And an India-based data production officer, a real named person, and an obligation to file a significant filing on the board. Okay. Practically, most companies watching this won't be designated, but if you are scaling fast into fintech, healthcare, health tech, ad tech, or a large consumer platform SaaS, you should be building as through ULB, because DPIs and audit trials or designation is considerably more painful than designated for them. And SDF is not Schedule 3. This next one causes real confusion in the market, and I would like to clear it up because I have seen consultants get it wrong. On the left, significant data fiduciary, the risk-based designation made by the government notification, it adds government duties, the DPAs, audit, DPO, not fixed use account. On the right, Schedule 3, this is a completely different thing. It names a specific classes, e-commerce platform, social media, intermediaries, with that 2 crore or more users, and online gaming platforms with 50 lakh or more. And what it imposes is a retention rule. Erase user personal data 3 years after their last activity, and 48 hours notice them that before you do. So being on Schedule T does not make you a SDF, and being an SDF does not put you on the Schedule T. One is the governance designation, the other is retention category with the user count trigger. Two different lists, two different consequences. If someone tells you you will be on SDF because you have 2 crore users, there are actually two different things. Okay, you have to keep in mind. So this is an penalties. I cannot say this is an exact penalty. I can say it might be the penalties. Okay, reasonable security safeguards up to 250 crores. The most expensive failure in the act. Note what that tells you about the government priorities, not paperwork, not notice. It's about security. And breach notification failure is up to 200 crores, which means covering up a breach can cost you almost as much as causing it. The instinct to stay quiet is now the expensive instinct. Okay. Children data also up to 200 crores. Say take gaming platform, coaching centers, anything with under 18 users. This is your number. Significant data fiduciary duties up to 150, and other breaches of Act are 50. Note that even the residual catch all category with 50 crores. Two features of this table I would underline. This is an act violation ceiling, not annual cap. So failures compound. So and they are a size agnostic, which I said stop, which means real world exposure lands hardest on small and mid-sized business. A 50 crore residual penalties, rounding error for the even for 100% company. The board and your right to appeal. Who enforces this? What recourse do I have? The regulator is the Data Production Board of India. It designed as a digital first body, it receives complaints, investigates breaches, and imposes penalties. How it runs? Inquiry, then hearing, then order. Conducted largely online, it can also direct remedial migration measures, not sure. Not just fines. That's what noting. The board can order you to fix something, not merely pay have anything broken. Appeals, you appeal a board order, TDSAT, the Telecom Disputes Settlement and Appellate Tribunal, okay, TDSAT, within 60 days. And one structural point that matters more than it sounds under DPDP, there is no private right of action. The individual cannot sue you directly for a data breach the way they could in some other justifications. Everything routes through the board. That's meaningfully better for businesses than the alternatives. You are facing one regulator with a defined process, not a class action. But it also means the board owns capacity and appetite will shape how the law actually feels in practice. Watch what it does in first year. Section 6, 3 special cases with catch people out. Anyone under 18, they are children. Verifiable parental consent before processing, not tick box saying I'm over 18 verified. And no behavioral tracking or targeted advertising directed to the children. So it's a full stop. Same protection extended to person with disabilities who have lawful guardian. So if you are in edutech or gaming or you're in a coaching institute, this is the highest risk area. So 200 crore ceiling, and we didn't know they are minors. It's a weak position when your product is a math app. This is where cross-border transfers. This is where I get to deliver some genuinely good news, because there was a lot of panic about the draft rules. India adopted backlist model. Transfer is permitted by default, except to countries government specifically restricts. That is not data localization. You do not repatriate your AWS workloads. You do not have to move your CRM onshore. A lot companies budgeted for migration they don't need. The myth come from the Jan 2025 draft and did not survey to the final rules. SDFs may face additional limits for specific categories of data. So if you are likely to be designated, keep watching this space. Here's the question I asked most often in my client meetings. What about the data we already collected? So this is what my clients mostly asking to me in the meetings. It isn't grandfathered. For personal data you collected before that, you must give a fresh notice telling people that you hold, why you hold it, and how you can withdraw consent and complain. Okay. The good news is you can keep processing it. You don't have to stop. You don't have to delete. But the re-notice obligation is immediate once the rule applies to you. And anyone who withdraws must be honored. In practical, let's say you have 50,000 row customer list built up over 5 years on a back of work. I agree to the terms and conditions tick box. Under DPDP, that concern is thin. It wasn't specific, it wasn't itemized, and most of the people have no idea what you are doing with their data. So your plain language re-notice same percentage will withdraw. And yes, that's unnoticeable, and yes, your list will definitely shrink. But look at the commercially for a second. People who withdraw were never converting AI anyway. Okay, what you are left within is a small list of people who have actually knowingly said yes. That is a better marketing asset, and if one and it's one you can defend. It's the only thing. And DPDP versus GDPR at a glance. For those of you who are already running GDPR compliance, you have heard. But are you done and assuming the two of the same is a specific way to fail? Lawful basis, the GDPR gives you six, including legitimate interest, the costs of European compliance. DPDP gives you consent plus a narrow set of legitimate users, much narrower if your European programming leans on legitimate interest. That reasons are not to port to India. Localization, GDPR, no DPDP, blacklist model with the possible extra of SDFs. Breach reporting for regulator. GDPR 72 hours, DPDP won't without delay, plus a 72 hours detailed report. And remember, remember if you're in India, you also got certain 6-hour clock running alongside. Maximum penalty GDPR 4% of global turnover. DPDP they have set around 250 crores per violation. For a large multinational, GDPR bites harder. For the Indian mid-sized company, DPDP bites harder. Private lawsuits, GDPR yes, DPDP no, regulatory routes only. Bottom line, GDPR compliance only gets you maybe 60% on the way. The gap you consent architecture, children rules, and the certain overlay. Last section, what do you actually do starting tomorrow? So assess month 1 to 3 data inventory and mapping. You cannot product data, you cannot find. So and almost every organization discuss personal data in place. Nobody expected a spreadsheet on a shared drive, a old marketing tool nobody cancelled, a WhatsApp group. Then a gap assessment against those 8 obligations I already showed and told you to take a screenshot if you wanted. Classify what you hold and why, and implement months 4 to 12. This is heavily lifted. Re-architecture concern. Rewrite your notices with plain language. Renegotiate vendor contracts so every processor is under proper agreement. Set and enforce retention policy. Validate. Then next is validation. Validate. Month 13 to 18. Build a breach run book, a rule book, and actually drill it. Yeah, run book nobody has rehearsed will not survey 6-hour clock definitely. Appoint your DPOs or grievancer officer and audit yourself before enforcement starts, not after. Work backwards from 14 of May 2027. If assessment takes 3 months and implementation takes 9, the last responsible date to start roughly 6 months from now. The 4 myths that will cost you. Before I close, the 4 things I hear most often, and each one is wrong. We use AWS, so we are compliant. Infrastructure is compliance. AWS gives you tools, it doesn't give you consent. Notice it does not give you consent, notice, rights to fulfill. Fiduciary carries the duty wherever the data physically sits. And next is we are B2B, so we are accept. Your B2B contacts are individual human beings. Their names, work emails, phone numbers, and personal data. There is no B2B crave out in this act. So next is we are too small, no turnover exception. So and no headcount exception. So it's a full stop for you also. Then ISO 27001 covers it. A security certificate is excellent evidence that you take security seriously, and it will help you on the safeguards requirement, but it says nothing about concern, notice, purpose, limitation, or data principles right to ensure. It's a one control in much wider program. So here comes how Pisence helps. A quick word on where we fit, and then I will take questions. Assess DPDP gap assessment and data mapping, finding where personal data actually lives in an organization and where you are exposed today. Then secure VAPT, vulnerability assessment, penetration testing, and hands-on implementation on the security safeguards, the rule name. 24/7 SOC monitoring and a testing breach runbook built around the both 6 and 72-hour clock. And operate DPO as a service, concern and notice architecture, audit ready documentation well before 2027. The reason we have built it in that order is simple. Most companies want to jump straight to writing a privacy policy, but you cannot write an accurate notice until you know what data you hold. And assessment first and always. So where does that leave you? The law is real, the boarding is sitting, the data is fixed, 14th of May 2027, and on the window between now and the then build time. So there is no waiting time. If you want to know where you stand, we are offering the DPDP readiness assessment. So no slides, no pitching. We'll walk you through your data flows and tell you honestly where the gaps are and what the shortest path to looks like. So you can reach out to us at sales@pisence.com, or you can reach out in WhatsApp, or you can call us by our number 908057582, and you can reach out to our website. You can check our website. We do other multiple services, SOC monitoring and VAPG testing for multi-sectors. So thank you.